Right. Greetings, everyone. Welcome to another episode of the Essential Talk podcast. What is essential to talk about today is international arbitration, or I rather say arbitration. This is something that is trending now, and the world is revolving around when it comes to settling the disputes. And to talk about the same, we have Mr. Alaxander Uff, who is a barrister in London and has an experience of over 2 decades when it comes to international investment arbitration and commercial arbitration. It is an honor to have you on board, sir.
Oh, thank you for having me. It's a pleasure to be here.
Right. So without any further delays, let's begin. Let's talk about arbitration. So, sir, as you're a barrister, in London, and arbitration hub, London is considered as the arbitration hub, right? And it's a very deadly combination when it comes to being a barrister and practicing international arbitration. So, what was that driving factor, which made you a barrister? Which motivated you to become a barrister and then pursue international arbitration?
Well, that's a good question, and I should say my career has followed a little bit of a non-traditional pathway.
Right.
And part of I think it's also important to realize that things have changed a little bit, especially in arbitration, since I started out in my career. In particular, when I started my career, this was round about 2000, arbitration was a pretty small niche field. It was comparatively unknown.
Right.
Most of the prominent arbitration practices were based in Paris, and actually most of the people in them had kind of run across arbitration rather by chance in their careers, found it interesting, and decided to stick with the field. But to give you some context, you didn't have all the kind of arbitration courses, postgraduate courses for arbitration that you have today. And it was actually quite difficult to study arbitration, certainly at an undergraduate level at that time.
Right.
So I qualified as an English barrister, and I was interested in international arbitration. And I did two things. The first thing I did was to start doing some work for a well-known English arbitrator, Martin Hunter, and
Right.
I spent several months doing what you'd kind of call tribunal secretary work, drafting procedural orders, drafting some correspondence, writing the formal parts of awards. And doing that, I got to sit in on several hearings, meet other arbitrators, meet arbitration lawyers, and got some really good first-hand experience about how arbitration actually worked. And then the second thing I did was I got on a train to Paris and went and talked to the major arbitration practices there. And this was a time when finding a young lawyer who was interested in practicing international arbitration was unusual enough that those people were very happy to sit and have a chat, have lunch. And by doing that, I educated myself about the arbitration field, who were the major practitioners, and what were they doing. And it was through those discussions, one of the firms I met was Freshfields. They said that they were hiring, so I applied to them and they offered me a job. And really that was how I started out as my career in international arbitration. Freshfields Paris, which certainly at that time was widely regarded as the world's leading arbitration practice.
Right. This is something that I guess no one knew that, the Paris one. Paris was the one who started off with the international arbitration as such when it comes to international level, right? So I just wanted to continue with this, that you said this. I love the part where you said that earlier people that earlier people used to pick up arbitration by chance, and they love the profession and they continued that. So I guess it's here as well. So since you started off 2 decades back when the international arbitration, and now since it's been 20 years, so what is that change that you have seen trend in the international arbitration which you have seen in the past decade? So what is that major change which international arbitration has seen over the 20 years according to you?
Well, I think the biggest change, if you like, is that arbitration has become mainstream. It's become so successful that, suddenly it is the preferred form of dispute resolution for major commercial parties. Um, it's and more people are realizing that it's an interesting, exciting and slightly different field, and it's a very effective way of resolving disputes. So really, there's a lot more of it. It's become more popular. There are today far more people practicing arbitration, so it's become a much bigger field. You could no longer describe it as a niche, and that of itself has consequences. There are when I started doing arbitration, there was a term that was often used, which was the arbitration mafia, which kind
Okay.
of referred to a pool of the kind of usual suspects, particularly as arbitrators, and it was usually the same people trying the same cases or repeated cases again and again. And one of the consequences of that was everybody knew everybody else. And you really couldn't say that today. Arbitration is so much bigger. There are so many more people sitting as arbitrators, and more disputes in more and different places. And one of the things that's come with growth is really a lot more diversity. People are sitting as arbitrator in different places, and as international commerce has spread
Right.
further throughout the world, there are more parties engaging with more regions, and also lawyers from a more diverse set of jurisdictions practicing arbitration. And you can also practice arbitration in more places. I mean, arbitration in London is far bigger today than it was when I started out. And really, to get that kind of work, I needed to move to Paris. And
Right.
nobody would complain about living in Paris, but I could not have got in London in 2000 the kind of experience that I did get working in a practice in Paris at that time.
Right. So I believe 20 years is a lot of time, and we have seen a significant change in when it comes to international arbitration. So this leads me to another question that international arbitration, as you mentioned, is very wide in nature, right? And it consists of a lot of subfields. I'll use the term. So for example, commercial arbitration, investment treaty arbitration, and a lot more, I believe. Right. So according to you, when it comes, since a lot of individuals nowadays are moving towards international arbitration, right, as choosing their career for practice, right? So what are those foundational factors that an individual should consider while choosing the area of practice under the international arbitration?
Well, look, my advice, honestly, is starting out in arbitration, I wouldn't worry too much about subfields. I think it's important to know about them. And really, I should have said earlier, investment treaty arbitration is one of the things that's really exploded over the last 20 years. I mean, when I did my first one, there were probably a dozen cases that had been tried in the kind of previous 40 years that investment treaty arbitration had been around. And since then, there have been hundreds, if not thousands of cases. But to go back to your question, I think specialization is something that will come as you get more senior, if you want it to. But as a junior trying to start out in arbitration, then really the aim should be to join a busy, active international arbitration practice. And you don't really want to curtail any of the options. I think just kind of getting some, if you like, flying hours under your belt, getting some real experience fighting cases, that's the best way to start. And if you say, I only want to do this kind of case or that kind of case, that's simply curtailing your options. And quite honestly, as a partner at Sherman and Sterling in particular, I would get to meet and review CVs of lots of junior lawyers applying for associate positions, intern positions. And I would not be looking particularly for someone who's taken firm views about they only want to do this kind of case or that kind of case. What I want is someone who's enthusiastic and will get involved and roll up their sleeves and turn their hands to whatever case comes through the door next. And it might be an investment treaty case, or it might be a construction case, or a M&A case, and whatever it is, I want someone who will be enthusiastic about that and roll up their sleeves and do the work.
Right. So it's all comes down to having a learning mindset and not limiting yourself to just one field, but exploring and practicing, almost every field under the international arbitration, if I'm not wrong.
Well, being willing to do so, yeah. That's it. That's exactly right. I mean, I think it's very helpful to be aware of the field and to be aware that there's this type of case or that type of case. But really, I think a lot of arbitration, you learn through doing it. And really, I mean, for someone managing a team, doing an arbitration, the last thing I want to hear is someone who thinks they're too smart for this type of case, or they only want to do a different type of case. That I want a team who's committed and who's going to work hard. Right.
I totally understand that. Right. So this is a small question that comes to my mind is that if an individual is completely new to arbitration per se, right? So according to you, and the London follows the barrister, actually UK follows the barrister and solicitor system, right? So if an individual is completely new to arbitration, so what is the preferred mode you suggest, that he should first become a solicitor and then go towards becoming a barrister, or it hardly doesn't matter? What's according to you should be the ideal route?
Look, I don't think there's one ideal. I think what I would say is that at the junior end, you are more likely to get a significant amount of work in the arbitration sphere if you join a law firm with an arbitration practice. I think the number of junior barristers doing substantial arbitration cases is very small. But that's to say, it's not rocket science. Not everybody wants to be a specialist. Not everybody wants to do only arbitration. And look, there are lots of different ways to do arbitration too. Not everybody has to be a specialist to do it.
Okay.
And part of the ethos of arbitration is to be a kind of broad church and to cover people from different backgrounds, different practices, and they're all welcome and to come and practice arbitration.
Right. So, earlier you mentioned that, which is actually a fact, that arbitration is a complex subject, right? And it's, generally studied at the postgraduate level, right? So I just wanted to ask that when it comes, there's a huge difference between when it comes to studying the theory and practicing, right? So what is that difference, like what it is like to study international arbitration and then practice international arbitration? I believe there are two separate worlds, I guess. So according to you, what's that?
Well, I think the answer to that is yes and no. Arbitration is an area where, and this is one of the fun things about it, where the theory does actually matter. And if you have a case where there's a challenge to jurisdiction, for example, you do end up reading and applying that case law and arguing about whether there is consent by all parties to the arbitration agreement, for example. And if there's not a firm basis for jurisdiction, then you've got a problem. So arbitration is a practice area where the theory you do get to engage with the theory more than probably a lot of other areas of law on a regular basis. And in fact, I've just been doing a case where there's been a dispute about jurisdiction, and it's been a lot of fun and very interesting, and we've had to develop quite a sophisticated jurisdictional theory for the case to go forward. And I've really enjoyed that. But to kind of come to your question, the theory of arbitration is more kind of focused on the legal framework which underpins it. in what circumstances do the parties validly consent to arbitration? What constitutes a valid arbitration agreement? In what circumstances will an arbitral award be recognized or will it not be recognized? And you need to have an eye to that. The practice of arbitration itself, on a day-to-day basis, it's really a form of litigation, and the skills that you need for that are not really different from the skills of any litigator. It's about reviewing and analyzing a fact pattern in a forensic and an incisive way, figuring out what is going to drive the outcome of the case and what is the best way to present that to the decision maker in a compelling, persuasive way.
Right.
And that's a kind of core of litigation skills, and you need to have that alongside the theoretical basis of arbitration, because you do need to understand, if something happens in the arbitration, is it likely to have implications for jurisdiction? Is it going to create difficulties? Does it create a basis on which the award might not be enforced? So both meet, and you do need both. But the core of litigating is not really all that different from any other form of litigation.
Right.
And just to complete your question, there are now some courses which teach arbitration by kind of following the normal procedural steps of an arbitration. So you'll look at a request for arbitration, jurisdictional issues, potential for challenging arbitrators, briefing the merits, and probably even some cross-examination and hearings. So there are people who are trying to teach arbitration in a more practical way, as well as the more kind of theoretical courses, if that's of interest.
Right. So since we were, just discussing that, that skills which a litigator requires is something that an arbitrator also, requires or should actually build. So according to you, is there if I ask you one core skill that every arbitrator should develop in practice or should actually have when he or she is practicing international arbitration, what is that one skill which is very important according to you?
Well, I think the core skill is just being a incisive litigator, and being good with case law and good with fighting cases. I mean, look, arbitration is something you can learn. I mean, there are a lot of courses around now, but I've always been quite a strong believer in learning by doing. Arbitration isn't rocket science, and you can learn it without doing those courses. So right. I think just having a smart, active mind and a disposition for being a disputes lawyer, which quite honestly not everybody has by any means. I mean, I think that's kind of really the core of being an arbitrator. What I would say on top of that is the way arbitration is different from other forms of litigation. One of the ways is that it tends to be a lot more flexible procedurally. And I've always found it helpful for me personally to understand that, and to understand what possibilities that creates to help you present your case in a more persuasive, compelling way. And you can be a little bit creative with your briefing. You don't have to just set out, the facts, the law, some conclusions, and then stick an introduction on it. You can really think, okay, for this particular case, I want to do something different. I'm going to present it this way. I'm going to break it into sub-issues and do the facts and the law for both. I'm going to, there are lots of possibilities, and really being able to think a little bit outside the box in terms of what's going to be the most compelling way to present your case is something that I think makes for a better arbitration lawyer, and allows people to be a little more creative than they would be with a very sort of fixed, rigid set of rules such as you often get in litigation.
Right. This brings me to one last question that I have in mind. is that since you have practiced worldwide when it comes to international arbitration, and have you seen, according to, is there any difference when it comes to practice if you go region by region? For example, that since you majorly practice in UK, and since you might have practiced in Paris and some other states, so when it comes to arbitration, is there any difference in practice when you move from region to region?
Well, the premise of arbitration is that you are almost invariably dealing with parties of different nationalities who are often represented by lawyers who are admitted in different jurisdictions. And arbitration is designed to accommodate those differences. And that really is an important part of the arbitral tribunal's role, is to kind of try and bridge that and make sure that there's a procedurally fair procedure. There's a level playing field where each party has an opportunity to present its case, regardless of the different backgrounds and expectations of the parties and their lawyers. So the whole premise of arbitration, one of the things that makes it fun actually, is having people from different backgrounds and different jurisdictions. And that obviously does mean that not everybody is going to get their way all the time in terms of the procedure. I mean, what I find is whenever you talk to a lawyer about procedure, they invariably think that whatever they were brought up with is the best way to do things, and everything else is inferior. And I have yet to meet a lawyer who doesn't think exactly the same thing about that, despite coming from completely different procedural backgrounds. So I mean, to give you some examples, if you were to have an arbitration, when I was working in New York, you would have kind of two US firms and US parties, and they would quite often agree to have depositions as part of the arbitration process, and then talk about applying the federal rules of civil procedure to what they'd call the discovery process. And that's very different from certainly how a continental European or even an English lawyer would view those issues. So there are parties with different expectations, and practices do change regionally, but the whole premise of arbitration is the kind of machinery to make international trade work and commerce work between different parties is to try and bridge and overcome those differences. And most of the time it does it pretty well. And there's also a lot of soft law instruments which claim to be a compromise, and the IBA rules on the taking of evidence is a good example of that, where it's supposed to be a combination of civil law and common law procedures for various evidentiary issues, particularly production of documents. So I think the perception is, on the whole, is weighted more towards the common law than the civil law, but it's still a compromise that was generated for precisely that reason. For example, so there's, but you're dealing with people from different backgrounds and with different expectations all of the time. And I actually remember one prominent arbitrator saying, well, you really get the most vehement and vicious disputes when you have two counsel from the same jurisdiction against each other. And people from different backgrounds often manage to recognize their differences and rub along a lot better.
Right. It's challenging and fun at the same point of time, I believe.
Exactly. That does make it a lot of fun, and I've always liked meeting people from different places and the international nature of practicing arbitration. And I've spent the majority of my career, in fact, living in places I wasn't born in, so I entirely embrace that international aspect of arbitration. It's one of the things that makes it fun.
Right. It helps you travel the world as well.
It does that too.
Right. Right. So with this, we come to an end to this particular podcast. Is there anything you want to address or say to our viewers?
Well, no particular thoughts. I mean, I'm obviously happy to answer any questions or follow up if anybody has any. So please don't hesitate to reach out if you'd like to. But it's been a pleasure talking to you. Thank you.
Right. Thank you. With this, we come to an end to this particular podcast. We'll see you in the next episode. Till that time, please do like, share, and subscribe The Essential Talk. Thank you.
Okay, thanks. Bye-bye.